The last one.
That's the last one.
This case is not just about missed parenting time. It's about defiance, manipulation, and an unraveling timeline that nearly exploded into a full-blown criminal charge. Judge Simpson presides over a contentious custody battle turned potential parental kidnapping case. Where court orders were questioned, social media became a legal landmine, and law enforcement found themselves in uncharted territory. At the center, Miss Lovely, a mother who claims she had valid doubts about a custody order's legitimacy, so much so she refused to return her child even after being served. But the prosecution argues something far more sinister, that she knowingly violated not one, but multiple court orders, and crossed state lines while ignoring direct police warnings. And then there's Mr. Johnston, the father, a former law enforcement officer turned frustrated parent. His testimony is meticulous: names, dates, orders, agency follow-ups. He paints a picture of a mother who sidestepped the system and kept their child from him for over 10 days. As the case unfolds, we'll hear about court orders allegedly denied, emergency motions filed and dismissed, CPS investigations, and a judge who's growing increasingly frustrated with blatant non-compliance. But here's the twist: was Miss Lovely genuinely confused about the court orders, or was that confusion a convenient smokescreen? The answer could determine whether this was a civil misunderstanding or a criminal act. Get ready, because this isn't just courtroom drama. It's a full-on legal chess match, packed with emotion, confusion, and a system pushed to its limit. Strap in.
Okay, here we go.
See that? Very official self-authenticated. Is that? I'm not sure.
Ready? Court does call the case of the people of the state of Michigan versus Lovely.
Yeah, I think you would, good afternoon, Jonathan Emmons on behalf of the people. And Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lovely, who stands to my right in court.
Okay, thank you. We're ready to proceed to exam.
Defense is ready. Yeah, people are ready to proceed in this matter. My understanding is that there's also some kind of a violation hearing. Did you want to do the exam and then kind of do everything all at once, or however?
Yes.
Perfect.
That's
Not that there's anybody else left. I'm going to call my first witness, Corey Johnson, but I have the officer in charge, Dusty Patel, also here with us today.
all right. Sir, please come forward. Be sworn. All right.
Raise your right hand to me. Comment swear or affirm testimony you're about to give, the truth, the truth, and nothing but the truth.
George, I think. Got it. All right, go. You may inquire.
Yeah, thank you. And good morning, Mr. John, or good afternoon, Mr. Johnson. Thank you for being here today. Just to kind of get right into it. With the court's permission, there's a child involved here. I'm just gonna refer to it as the child, so I'm not putting his name.
That is fine.
This moment sets the tone for how sensitive and high stakes this entire hearing really is. By choosing to refer to the child only as the child, the prosecutor is signaling to the court and the audience that this case goes beyond custody arrangements. It's about protecting a vulnerable minor at the center of a volatile legal and emotional storm. This isn't just a squabble between exes, it's about a child's well-being being pulled back and forth like a legal tug-of-war. The prosecution also shows procedural clarity by getting early judicial permission to proceed in this respectful way. It's a small but vital move to keep focus where it belongs. If you've ever watched family court cases, you know how rare it is to see this level of decorum in emotionally charged settings. How would you feel if your co-parent refused to return your child after your scheduled custody time? No explanation, no follow-up. Would you call the cops or try to reason it out? Let us know in the comments.
And likewise, if defense could. Do you have a son? Yes, I do. Okay, and who is the mother of that child?
Defendant.
Okay, and just identify her. Okay, and is that somebody who you see here in the courtroom today? And how do you know Miss Lovely?
She's an white.
Okay, and you guys are obviously divorced then?
Yeah.
When was that divorce, when did that become effective?
2019.
Okay, and as such, out of that divorce proceeding, was there a custody arrangement that was entered into regarding your child
Yes.
in September of 2022?
Yes.
Can you briefly tell us what the terms of that arrangement were?
Yes, we each had 50-50 custody, joint custody, and then we did our exchanges on Fridays.
Okay, and so is that one parent would drop them off at school, the other parent would then pick them up?
Yes, you complete your week by dropping them off on Friday, then the other parent would start their week picking them up.
Okay, so I want to fast forward to Thursday of I'm sorry, February of 2023. Did anything change regarding that arrangement, that custody arrangement?
Yes, that the first week of February, I would have had custody of my son.
This is where the timeline begins to crack open, and timing in a custody case like this is everything. Mr. Johnston clearly establishes that per the custody agreement, February's first week was his. That means there was no ambiguity in the schedule. He was legally entitled to have his son. But what followed was a derailment of that schedule, one that prosecutors argue was not just inconvenient, but criminal. His calm tone masks a real frustration. When parenting time is blocked, especially after a contentious divorce, it doesn't just break the legal agreement, it tears at the fabric of trust between co-parents. And for Mr. Johnston, a former officer, it also undermines his belief in the system. This one statement, "I would have had custody of my son," echoes throughout the entire case, because everything that follows hinges on that one detail being respected or ignored.
And I was contacted by stated they're investigating the claims that she had made against me. They turned out to be false. So I believe it was like the 6th, they contacted me and they said, "We're going to go back to normal custody. We advised her to continue like you should be, dropping him off at school, and I would pick him up, et cetera." And that never happened.
Okay,
He was never
so February 6th of 2023, I believe that was a Monday.
returned. Monday or Tuesday.
Okay. You were supposed to have the child on what day? That Friday, so roughly the 3rd. I looked at a calendar earlier.
Yeah, I'd have to look at it.
Okay.
Well, hold on. I just want to make sure. On the 3rd would have been your pickup, the beginning of your custody.
Yes.
Okay, go ahead.
And then that should have terminated with you dropping the child off on the 10th.
Yeah, Friday.
Okay.
Whatever the Fridays were. Got it.
All right. And so then now turning to the 6th of February, CPS gives you the okay to resume your pickup. Do you have any interaction with the defendant regarding the child exchange on the 6th?
The prosecutor zeroes in on the real pivot point of this case, the interaction or lack thereof between the parents on February 6th. If communication broke down here, the ripple effects could justify every legal motion that followed. What's being subtly explored is intent. Did Miss Lovely intentionally block the child exchange? Or did something else cause the breakdown? Confusion, fear, maybe even miscommunication? Because if it was intentional, that opens the door to willful non-compliance, and that's the path to a criminal charge. Also note, CPS had already advised to resume normal custody. That means any deviation from the schedule would now be seen as defiance of both legal and agency guidance. This one moment flips the narrative from civil confusion to possible legal defiance.
Yeah, she contacted me on our family wizard.
Okay.
Told me she was not returning.
Okay. Prior to February 6th, had you been observing her social media feeds?
Yes.
Okay. And did you have any concerns about what the defendant was going to do with herself and the child.
Objection, Your Honor, as to the relevance of what's on her, allegedly on her social media feed, certainly with regard to what he may have speculated he was worried about her doing.
Well, but that goes to his state of mind as to everything. I'll overrule the objection. I'll hear it.
Go ahead. Yeah, so had you been kind of monitoring her social media?
Yes, I was concerned that she was going to take out of state.
Okay. With a specific destination?
New York, that's all I knew.
Okay. And so did you share those concerns that you had with the defendant at all?
Yes, I told her that would be a violation. We were required to provide an itinerary to front of work, and that never happened.
Okay.
I verified that with Sarah Mazer. She said they hadn't received an itinerary, and that what she provided wasn't appropriate.
That one sentence might be the quiet bombshell of this case. When the defendant allegedly provided an inappropriate itinerary, it implies more than a simple mix-up. In custody disputes, courts often require detailed travel plans where, when, with whom, especially when interstate travel is involved. If her itinerary was vague, incomplete, or suspicious, it could signal an intent to flee, not just travel. This claim also explains why the prosecution and the court later respond so seriously. It wasn't just that she didn't drop the child off, it was that she gave a shaky explanation that didn't align with custody obligations. The legal weight of a failed or invalid itinerary could become Exhibit A in proving deliberate concealment.
Okay. So on the 6th, obviously the child does not return to your care.
Right.
Okay. What happens then on the 7th?
I contacted and law enforcement in reference to the issue. A order was filled out and sent to the judge by a friend of court to pick my son up and return him to me. That was signed by Judge O'Brien.
Okay. Did you anticipate that you were going to be able to pick up your child from school that day?
Yeah,
Okay. Did you reach out to the school at all?
I did, and they told me that he hadn't been brought that day.
Okay.
I think he said it was like mental health or something like that.
You obviously didn't excuse him. Okay. Okay. All right. The order, when you contacted a friend of the court, were you able to receive a copy of the order from friend of the court?
This is where the legal gears start turning fast. Once Mr. Johnston confirms he obtained a copy of the official court order, the narrative shifts from a parental dispute into a certified legal violation. When you're armed with an enforceable court order and still can't get your child back, that's when the law stops being polite and starts knocking on doors. It's also a powerful moment for the judge and jury. There's no he said, she said here. There's a document signed by a judge stating what's supposed to happen. And that's why the stakes are so high. Ignoring such an order doesn't just make you a difficult co-parent, it could make you a defendant in a criminal trial.
If I did.
Okay. I'm going to approach with what's been marked as people's proposed exhibit number 1.
If I may, Your Honor.
Yes, you may.
All right, Mr. Johnson, that exhibit that I've handed you, you've had an opportunity to review that before testifying today?
Yes.
And is that something that you're familiar with?
Yes, this is the order that they sent to the judge. That she
Okay.
signed to pick up.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien at the 22nd Circuit Court?
Yeah.
Okay.
Got it.
And that's the order. What was that order informing what was supposed to happen with the child?
I believe, let me read it just to clarify. Says that she's supposed to return to me immediately and not leave the state of Michigan.
This line is everything. If not, leave the state of Michigan. It clarifies the gravity of the order Miss Lovely allegedly defied. The court wasn't just telling her to return the child, it was legally restricting her from crossing state lines. That's huge. Why? Because once a parent withholds a child and crosses state boundaries, it can escalate into parental kidnapping under federal statutes. This shows the court anticipated possible evasion. The moment Miss Lovely ignored this, she didn't just break a rule, she potentially triggered a criminal jurisdiction issue. And from a law enforcement standpoint, this detail explains why multiple agencies got involved. If you're wondering why state police and multi-jurisdictional units were on this, it's because this was no longer a family disagreement. It was a legal emergency.
Okay. Your Honor, unless there's any objection or voir dire on the issue, I'm going to move to admit People's Proposed Exhibit number 1.
No objection for purposes of exam.
Exhibit 1 is admitted.
Did the court want to review that?
Yeah, I'll say.
Thank you.
Thank you. Standard order. Okay. Go
Thank
ahead.
you. So now turning your attention then, so that February 7th, that order gets signed. You said that you contacted police. What agency did you contact?
I contacted Northfield Township, and I believe it was a detective that called me back. He called me back.
Okay.
I sent him that document that I had by email. And then he basically said because of the multi-jurisdictional thing that he was going to forward it to the state police.
Okay. And as such, did you end up later that day speaking to Trooper Pitzel? Pitzel. It rolls off the tongue. Pitzel. Okay. All right. And where did you speak to him at? Where did he come to your house?
No,
Okay. You spoke to him over the phone. Did he? Well, you kind of explained the situation to him as best you could. Okay. All right. Moving forward to Friday the 10th, had you received custody of your child by the 10th?
No.
Okay. Then moving forward to the 13th, that Monday, February 13th, by that point in time, had you received custody of your child? Okay. And it's your understanding that pursuant to the order, the child was supposed to remain in your care until further order of the court.
This new phrase locks everything in until further order of the court. This means any previous back and forth about who gets which week is now off the table. It's no longer a shared custody arrangement. It's full, court-ordered possession by the father, with no ambiguity until the court says otherwise. That's a seismic shift. For Miss Lovely, this was the moment to comply or face consequences. And yet, according to testimony, she still didn't return the child, even after knowing this order was in place. Here's what viewers need to understand. When a judge issues an until further order clause, it means the previous schedule is frozen. The court takes full control. Defying that isn't just a mistake, it's a legal rebellion.
Okay. All right. So then tell me what happens on the 14th of February. Had you, on the 14th of February, so this is Tuesday, had you received custody of your child? Okay. So what did you do or what happened in terms of that custody arrangement?
And contacted front court and law enforcement and advised them that at that point she wasn't even in Michigan anymore.
Boom. That's the moment everything tilts toward criminal. When Mr. Johnston testifies that Miss Lovely was no longer even in the state, it flips the switch from domestic dispute to potential interstate custodial interference. This isn't just defiance, it's flight. And in family court, fleeing across state lines after a court order to stay put is the legal equivalent of setting off a flare. It's not just ignoring your co-parent, it's ignoring the court and removing the child from the state's legal protection zone. The implication, she didn't just violate custody, she ran. And from a prosecutorial standpoint, that's golden. It shows intent. A judge could easily interpret this not as confusion, but as evasion. And for viewers, just imagine your child is suddenly taken out of state, and you have no idea where they are. What would you do? Would you call the police immediately, or try to resolve it privately first? Drop your answer below.
I mentioned on her foundation as to where she was.
I can, if it,
Well, he is, as I understand his statement, whether it's true or not, that's what he's indicating. So there may not be foundation for what it is, and the court will give it whatever weight I give that statement, but I'm going to overrule the objection. Go ahead.
thank you. Go ahead. So I'm sorry, you reached out to friend of the court. You gave them some information.
Yes.
What happened as a result of that information?
They submitted another order to the judge And this was for her, this was terminating her parental rights, and she had until the 24th. It's an ultimatum. Then she had to return them to the parental court by then. That was the latest, but it was to immediately do that.
The 24th of February.
Yes, sir.
Thank you. And if I may approach with people's proposed exhibit number 2. The 14th.
Yes, you may.
Thank you. Mr. Johnson, you've been handed what's been marked as people's proposed exhibit number 2. We just talked about the court order, the document in front of you. Do you recognize that item?
Yes.
Likewise, did you have an opportunity to view that before testifying in court today?
I have.
Okay. And is that a fair and accurate copy of the order that was submitted and signed by Judge O'Brien on the 14th of February of this year?
February 14th, Valentine's Day, and the judge just handed down a legal ultimatum. This second order isn't just a repeat of the first, it's a shift in tone. It terminates the mother's access and puts all the legal weight on the father's side. The court gave her a final, clear deadline to return the child by February 24th, and the key phrase here is immediately, or else. This kind of language is rare unless the court believes a party is actively undermining its authority. And based on what we've heard, missed pickups, defiance of officers crossing state lines, Judge O'Brien was likely fed up. This order becomes the prosecution's linchpin. If the first one left room for debate, the second one slammed the door shut. It set an unmistakable tone: comply now or face serious consequences. For Miss Lovely, this wasn't just a custody dispute anymore. It was a countdown to criminal charges.
Yes, it was.
Okay. And unless there's any objection or voir dire on the issue, I'm going to move to admit people's proposed exhibit number 2.
No objection for exam purposes, Judge.
Exhibit 2 is admitted.
All right. So then this order gets signed without telling me what you spoke to. Had you been communicating back and forth with the trooper during this period of time? Okay.
He advised the contact.
Well, don't tell me what he told you. I just want to know if there was still that communication. Okay.
Keep me updated on the status of the.
And had you been communicating with the defendant at all, sending either via Family Wizard or otherwise?
No, I had sent her a message stating that I was contacting the authorities.
Let's pause here. This detail might seem small, but it carries massive legal weight. When Mr. Johnston says he told Miss Lovely he was contacting authorities and she still didn't respond, that silence can be interpreted as willful non-compliance. Courts and cops don't just look at what you do, they look at what you don't do. And her complete lack of response sends a loud message: I'm not playing by the rules. This also deflates any later claim that she was confused or didn't understand the order. She was told, she was warned, and she didn't act. It's the kind of omission that prosecutors love, because it implies she had a choice and chose to ignore it. And in family court, silence can speak volumes.
She didn't return my child.
Did she ever respond in any kind of way? Okay. All right. So then to finish this up, when was the next time you actually received custody of your child?
I called the school Wednesday or Thursday. It was like the 16th, I think, that week. And they said he was there, that he had been dropped off. And so I told them that I would be there early to pick him up. And I had the order. I gave them a copy of that. And so they were aware that I had custody of him.
Okay. All right. And that was February, you believe, 16th of 2023, Thursday? Okay.
After nearly 2 full weeks of custody chaos, February 16th marks the first time Mr. Johnston finally gets his son back. But let's talk about what that means. By the time this handoff happened, at least 2 court orders had been issued, police had visited Miss Lovely, and multiple agencies were involved. This wasn't a routine transfer, it was the result of mounting legal pressure and official intervention. It also reframes the defense's narrative. If Miss Lovely was waiting for clarity, Why return the child only after formal enforcement and multiple legal warnings? The timing makes it look less like a misunderstanding and more like compliance under pressure. This moment is crucial because it's not just about the father getting his child, it's about how much institutional force had to be applied to make it happen.
And again, at that point in time, to the best of your knowledge, between February, well, I guess 6th and February 24th, so this is after communicating with CPS, to I'm sorry, February 16th. It was the defendant that was the only barrier between you and having custody of your child.
Judge Simpson's line here is razor sharp. The only barrier between you and your child was the defendant. That cuts through everything. It's a framing statement, and one that sets the legal tone for the rest of the hearing, because it suggests that nothing else, not court delays, not confusion, not red tape, stood in the way of this child's return except Miss Lovely herself. From a judicial standpoint, that's damning. Judges often look for patterns of interference in custody violations, and when there's no outside reason for the delay, no illness, no emergencies, no conflicting orders, it highlights the parent's personal choices. This statement is Judge Simpson telegraphing exactly where he sees the fault line in this case. And that kind of clarity often signals how the final ruling will unfold.
Okay. There was no communication that he was missing or anything to that extent. And in fact, had you spoken to your son during that intervening period of time?
Not allowed to have a phone call with him, just the one.
Okay. You had one phone conversation with him? You recognized his voice? Okay. All right. And I guess, how old is your child? Okay. So he doesn't, he may, I guess, but does he have a phone? Okay. So when you spoke to him,
Yes.
How did you get in contact with him?
We are required to call each other's cell phone.
This part confirms something subtle but crucial: communication between co-parents was still possible. Despite everything, despite orders and conflicts and accusations, they still had a method to reach each other: cell phones. So why didn't Miss Lovely use that channel to clarify the custody confusion? Why didn't she explain her hesitation or attempt a compromise? The fact that Mr. Johnston reached out, informed her about law enforcement involvement, and still got silence, while she had access to communicate, undermines any claim that she was just unsure. In legal terms, courts expect reasonable effort to resolve conflicts before they escalate. And this proves that she had both the means and opportunity to resolve things, but didn't.
Okay.
Hold on, take cell phone.
Okay. And so you called the defendant's cell phone and you were able to speak to the son.
Yeah.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this witness.
All right. Before you begin cross-examination, I just want to clarify one thing. The first order, sir, that was signed on by Judge O'Brien on the 7th, there was an indication that the child was to be returned to you, that your understanding was that the child was supposed to be returned and remain in your custody.
Yeah.
As I'm reading this,
Go back to 50/50, our regular agreement.
okay,
I think
that's fair. And if I'm counting out the dates, had the child would not have been returned to you really until the 14th, right? If I've got it.
I was supposed to have him that first week, of the 3rd.
Correct. So you would have the 3rd basically through the 9th.
Yeah.
Right? Then the defendant would have the 10th through the 13th. And then your next time would have been the 14th and beyond.
The 17th.
Or the 7th.
Yeah. Whatever that Friday would have been.
Yes, the 17th and beyond, I guess.
Yeah.
Ah, The calendar breakdown. Welcome to the courtroom version of playing 4D chess. Here, Judge Simpson tries to clarify the exact custody timeline, and it's not just for clarity's sake. It's to determine when the alleged interference occurred and how long it lasted. Because in a criminal charge like custodial interference, duration matters. Every day of withheld parenting time strengthens the case. So if Miss Lovely missed just one scheduled pickup, that's a problem. But if she withheld the child for over a week in defiance of orders, that's the very foundation of the charge. And the confusion Judge Simpson expresses, it reflects how messy these custody orders can get. But even in that mess, the key question remains: once she was told what to do, did she comply? The answer will decide everything.
So I guess, okay, so here's what I'm trying to figure out. I'm looking at this order, and I'll let you see it again, the order of February 7th. And it indicates that they're ordered to immediately return the minor child to defendant's father custody care and so on. Had that order been effectuated on the 7th, you would have then had the child from the 7th to what, the 10th?
Yeah.
Okay. And that's what didn't happen. Okay.
I didn't get him on the 3rd. I didn't have him. He was never returned. I never got him that week at all.
Right.
Yeah.
So, but what I'm saying is the time, I don't know really what I'm saying. What I'm indicating is you didn't get the child on the 3rd. The order to return the child to you signed the 7th. But if everything were to go back, really, there's like 3 days from the time of the order that it didn't happen. I mean, from the time of these orders, right? 3 or 4 days. Okay. The week then of, oh, let me just stop there for a moment. Because one of the questions the prosecutor asked you then is, on that order, that the child was to remain in your custody. That's not quite correct. On the 7th, is that right?
I believe she's supposed to be returned to me so we can continue our parenting time.
Okay, so, okay, that's something different. That's what I'm trying to figure out. On the 7th, the judge is ordering that the child be returned to you as though this interruption had not occurred. And then it would go back to the normal schedule, right? So from the 10th to the 17th, the defendant would have had primary possession of the child at that point, not really custody, but possession.
Yeah.
What interrupts that, though, is then the order of the 14th, which then says, and this may have, I just want to be clear on it because it may be what you were talking about, the 14th order. That order doesn't, as I'm reading it, isn't now referencing the parenting time. That order is saying this child goes to the father. That's it, until the court says otherwise.
This moment cements the legal shift. Judge Simpson interprets the February 14th order as a full override of the shared custody schedule. It's now the father's custody by default, until further notice. The implications, huge. This doesn't just reset the week-on/week off cycle. It removes Miss Lovely from the equation entirely. And it removes any ambiguity moving forward. From this point on, any refusal to return the child isn't just violating a parenting agreement, it's disobeying a direct standing court order. This ruling also sets up the final phase of the prosecution's argument that Miss Lovely's actions weren't just emotional or chaotic, they were a pattern of calculated defiance.
Is that your understanding?
Yes.
Okay. Okay. Pardon?
That's how friend the court explained it to me as well.
I probably did a better job though, right?
Judge Simpson's dry humor here might get a laugh, but don't miss the subtle punch behind it. He's highlighting something critical. Miss Lovely didn't fully grasp the order, but she didn't ask for clarification either. The judge is pointing out that had she simply asked, anyone could have helped her understand exactly what she needed to do. Instead, she gambled on her own interpretation. This moment reveals a core frustration judges often have: people ignoring court orders, not out of malice, but out of confidence in their own misunderstandings. But guess what? That confidence won't save you in court. It's also a judicial warning shot. Simpson is reminding everyone watching, including the defendant, that "I didn't understand" is not a valid legal defense if you never asked for help in the first place. If you're handed an order from a sitting judge and you don't follow it, you're responsible, confusion or not.
Okay, thank you. All right, thank you. No, it's okay. All right. Cross-examination.
Judge, if I could just have a moment.
Yeah.
May I retrieve the exhibits?
Happen.
Mr. Johnson, are you currently employed? How?
I work at Diablo Salsa.
You do what?
I work at Little Diablo Salsa, but more like,
Little Diablo Salsa. Were you previously employed in law enforcement?
uh,
When were you employed in law enforcement?
in 19.
How long were you in law enforcement prior to that?
Your Honor, I guess I'm going to object to the relevance of the question.
What is the relevance?
Judge, if I'm allowed to understand his involvement with law enforcement, it might explain why he chose to involve law enforcement in this in order to deal with what is a civil matter.
I don't know. I'll let you go. I don't think it's going to matter to the court, because if a child's withheld against a court order, I don't know that that's a civil matter. But
This is where the defense tries to reframe everything. They argue this is a civil matter, not a criminal one. A bold move, but a risky one. Why? Because civil matters are handled in family court. Criminal matters involve law enforcement, orders, and real consequences. But Judge Simpson quickly swats this down. When a parent knowingly defies a court order and withholds a child, it crosses into criminal territory, especially when the order was served and law enforcement got involved. This isn't a vague disagreement over holiday schedules. It's a custody order issued by a judge, followed by multiple direct refusals to comply. That's interference, not miscommunication. By trying to downplay the case, the defense risks looking dismissive, and in custody violations, minimizing the impact on the other parent, and the child doesn't win sympathy. It raises suspicion. This moment is key. The courtroom moves from interpretation to enforcement, and the stakes, they just became criminal.
I'll let you have your definition. Go for it.
How long, when did you start working in law enforcement? And where did you work?
Police department. I worked for Hamburg Township, Northfield Township, and shortly, a little short stay at like the Golden Stockbridge and reserve work.
Prior to the reserve work, you, Northfield, Hamburg, and Pinckney, you were working there as a police officer? Would you describe this, the child custody arrangement in the course of your divorce as contentious?
Somewhat, yeah.
And this all started when Ms. Lovely filed a Child Protective Services complaint against you, correct?
And what else?
This particular incident.
Yes,
When did that happen?
I believe it was beginning of February. Amanda Moore contacted me from CPS in Oakland County.
So early February, CPS contacted you, indicated that an investigation was being started. And you were told that it was based on allegations made by Ms. Lovely.
Yes.
And you testified that investigation was closed.
Yes.
When did that happen?
That was the 6th.
And how were you made aware of that?
I spoke to a man or the investigator.
On February 6th or February 7th, you said you contacted a friend of the court.
Yeah.
Did you also file an ex parte motion and that motion was denied, correct?
Here's a twist. Most viewers might miss, Mr. Johnston himself filed an ex parte motion that was denied, meaning the court didn't immediately side with him either. This actually makes the prosecution's argument stronger. Why? Because instead of reacting emotionally or retaliating, Mr. Johnston followed proper legal channels, even when they didn't go his way. He didn't take the child. He didn't escalate. He waited for the system to work, and eventually it did, with 2 separate court orders enforcing his custody rights. Compare that to Miss Lovely's approach, ignoring orders, rejecting police advisement, and ultimately refusing to return the child even after judicial confirmation. This stark contrast builds the case's narrative spine. One parent followed the rules, the other didn't. And in family court, especially with a child involved, that's a storyline judges take very seriously. It turns this from a he said, she said into a clear chain of compliance versus defiance.
Yes, because they authorized the other one, that private court.
But you filed a motion and that motion was denied.
Yes.
Okay.
An ex parte motion. What?
That was an ex parte motion to compel your parenting time, correct? Judge, I have no further questions.
I don't have any redirect.
All right, you may step down. Thank you. Any additional witnesses for the people?
I'm gonna call the trooper. And
Sir, please come forward and be sworn.
Yes.
Yes, me?
I am Trooper Dustin Peaksall. Do you want me to spell it?
Yes, okay.
It's P-I-T, Susan Charlie, yeah.
Why is that so hard, Mr. Emmons?
You just,
And I just noticed that when you called him to the stand, you
Yeah,
used the last name. You just used
I
his
asked-
title. Okay, I'm just saying,
you're on to my
I was-
ways.
I was paying attention, but go ahead. You may inquire.
Thank you. Trooper Pitzell, thank you for being here today. I want to turn your attention. How long have you been employed with the Michigan State Police? Thank you. And were you employed in that capacity early February of 2023?
yes.
Did you become involved in incident between a custody issue?
This is the exact moment law enforcement gets fully looped in, and you can feel the tone shift. Up until now, it's been mostly legal motions and missed exchanges. But when Trooper Pizzell confirms involvement in a custody issue, the courtroom acknowledges this situation has crossed into real enforcement territory. What's important here is that it wasn't Mr. Johnston's word that launched this, it was a multi-jurisdictional referral. One department referred it to another. That tells us this wasn't seen as a minor parenting squabble. It was already being treated with legal urgency. And then the trooper does something pivotal. He goes directly to Miss Lovely's residence. Not a phone call, not a text, an in-person visit. That adds serious legal weight. If law enforcement visits you in person, shows you a court order, and advises consequences, and you still don't comply, that's no longer about parental disagreement. That's resisting legal authority.
Between Alante Lovely and Corey Johnston.
Yes.
Thank you. Who did you first, or how did you first get involved in this information? And again, I would respect it to the extent that you have to refer to the child, just refer to it as the child.
At first, I was dispatched to an assistant agency. I was I from my dispatch notes, I was advised to contact, Detective Buxton, I believe his name was.
Thank you. And I think that's Buxton.
That's correct. Yeah. Township Police Department. I contacted him and he advised me of the dispute that we're here for today.
Okay. We had some testimony earlier about the court order. As a result of that communication with the Detective Buxton, were you able to receive some kind of court order in some kind of way?
Yes, he forwarded the email to me and
Okay.
I was able to review and see the court order as well.
Okay. After speaking to the detective, based on the information that he gave you, you have a telephone conversation with Johnston?
Yes,
Okay. Did you get some line information from him?
a little bit more information on what Detective Buxton was able to provide.
Now you have the information from the Northfield Township Police as well as from Mr. Johnston. What was your next step of your investigation to assist with this situation?
My next step was to make contact with Miss Lovely and I guess attempt to persuade her to comply with the court order.
Okay, and did you do that?
Yes, I did.
Where did you speak with Miss Lovely?
I spoke with her at her residence in South Line.
Okay. And for all intents and purposes, that's I think there's a small part of South Lyon that's in Washtenaw County, but her residence is in the Oakland part.
Correct, it is in Oakland.
Okay. And is the defendant, is that somebody who you see in the courtroom today?
Yes,
Just need you to point to her and tell us what she's wearing.
it's the female with a kind of white shirt with flowers on it,
Thank you.
more kind of beige.
And for the record, Your Honor, the witnesses identified the defendant.
And record shall so reflect without objection.
And thank you. Did you have a conversation with the defendant?
Yes, good.
And did you talk about the court order?
I discussed it with her. We talked through it together, yes.
Okay, and what was her response in regards to you showing her this order that she's supposed to return the child?
She advised me that she would not return the child.
Okay,
This is the core of the entire prosecution. Miss Lovely flat out refused to return the child, even after being handed a signed court order. Not, I need clarification. Not, let me talk to my lawyer. She simply said, no. That's the legal equivalent of standing in front of a judge and saying, I make my own rules. It also gives prosecutors a crystal clear narrative. They don't have to infer intent. She stated it right to the officer's face. No ambiguity, no miscommunication. This moment is what they call a clean fact in trial strategy. It's not up for debate. It happened. And it tells the judge and jury that every argument after this point about confusion or waiting for confirmation is retroactive damage control. From here, the defense will have to work overtime to shift the focus away from this one moment, because it's the nail in the coffin for their case.
when she advised that she wasn't going to return the child, what did you do?
I told her I would be in contact with her within 24 hours. And to confirm whether she would return or not return the child.
Okay. Did you inform her of maybe some of the consequences of not returning the child?
Yes, I did. I informed her that if she failed to return the child within 4 hours, that charges would be sent up against her.
Okay. Did she, in some way, show some kind of acknowledgement that she understood what you were saying?
Yes.
Okay. So then, did you follow up with the parties at some point in time later?
Yes, on February 10th, I called Mr. Johnson again to confirm whether his son or whether the child had been and he advised me he had not been returned.
Okay. And so, based on the information that you got from Mr. Johnson, did you then speak to Miss Lovely again?
Yes.
And what did Miss Lovely tell you about that?
Miss Lovely told me that she once again did not return the child and that she questioned the validity of the court document that I provided her.
Okay. When she questioned the validity of the court document, did you offer to do anything for her?
I did, yes.
Okay. And what was that?
I offered to I believe that was a Friday night, courts were closed. I told her, hey, I'll go down to the 22nd Circuit Court as well and confirm that this is indeed a valid document.
Trooper Pizel's actions here are rare and commendable. Most officers wouldn't take it upon themselves to personally verify a custody order with the circuit court, but he did. That shows the level of patience and professionalism that was extended toward Miss Lovely, even after she'd already refused to comply. And the fact that he verified it on February 13th, nearly a week after she was first served, removes any lingering excuses. What's powerful here is that Miss Lovely had multiple chances. First, to comply. Then to question the order. Then to accept the officer's confirmation. She declined all three. This timeline makes it impossible for her to argue that she didn't know, because the record shows she did know, and still chose not to act. That's not just disobedience, it's willful interference. And legally, that's where intent is proven.
Prove to her that yes, this is a valid document.
Okay, and did you do that? Did you follow up with the 22nd Circuit Court?
Yes.
Okay, did you get some kind of confirmation about the validity of the document?
Yes, I had spoken to one of the clerks, I believe her name was Miss Thompson, and she confirmed that that document was signed on the 7th by the judge's name is spacing right on my mind here, but
Judge O'Brien?
Judge O'Brien, thank
Thank
you. And she confirmed that that was a valid document.
Okay, and did you then relay that information to Miss Lovely?
Yes, I did.
Okay, so you've now told her about it on the 7th, gave her to the 10th to comply, and then on the 13th, tell her that it's a real court order. What was her response to you in regards to that information?
Once again, she told me she was refusing to return the child, and
Double refusal. This seals the deal. Trooper Pizzell didn't just give Miss Lovely a warning on the 7th. He followed up again on the 10th. And after confirming the order's legitimacy with the court, she still refused. This eliminates any remaining gray area. It's now clear this was a calculated decision. She weighed her options, heard the legal risk, knew the consequences, and said no anyway. From a legal standpoint, this shows a continued pattern of defiance, which is one of the strongest elements in any custodial interference case. It proves this wasn't a lapse in judgment. It was an ongoing refusal to comply with court authority. For Judge Simpson, this confirms everything the prosecution argued. And for viewers watching, this is the climax of the custody battle, the point where refusal transforms into legal liability.
after a brief few words, she hung up on me.
Okay. Thank you. Your Honor, with that, I don't have any other questions for this witness.
Cross-examination.
Thank you, Judge. Trooper, in the 4.5 years that you've worked for the state police, is this a common thing, common part of your duties?
I'm sorry, what do you mean as in?
I guess is
Are you-
serving orders for child custody, is that a common part of your duties?
In my 4.5 years, this is the first time I've had to do it.
The only time you've ever had to do it is in this case,
Yes,
so it's unusual. And you indicated that you spoke, well, I guess let me circle back. You received the order from Detective Buxton, correct?
yes.
And where did Detective Buxton get it from?
And he advised me that he received it from Mr. Johnson.
From Mr. Johnston.
Yeah.
So Detective Buxton didn't get it directly from the court either,
Unless he actually,
to your knowledge.
to my knowledge.
Okay. So you then told, as you indicated, you met with Ms. Lovely and you told her about the order, and she indicated that she had doubts about its authenticity, correct?
Yes,
And you testified already, but that she told you that a motion had to that effect had been denied, correct?
yes,
Right. So she asked you to independently verify that that was accurate, and you agreed to do that.
yes,
And you told her that you would do that.
yes,
Okay. And then by the time you were able to do that was September 10th, correct?
to
To
Yeah.
verify the document was authentic.
the 13th.
February, not September.
She requested on the 10th for me to verify the document, not on the 7th.
Okay, so you agreed to do it on the 10th,
Correct,
and then you verified it on the 13th.
correct. 10th was a Friday night, courts were closed.
Right.
The 13th would have been the earliest. That was Monday morning.
So she had indicated, when did she indicate to you that she was concerned about the veracity of the document?
On the 10th.
She didn't tell you that on the 7th?
I do believe she probably did indicate it on the 7th.
Okay.
I don't recall.
Okay, so things she told you on the 7th, she certainly told you about the CPS investigation on the 7th.
Yes, she did.
Okay. Judge, if I could just have a moment.
You can.
Did you ever attempt to independently verify that that order had been entered prior to February 10th?
No.
You didn't look into Odyssey or any other system?
Yes, I did.
You did?
Yes.
Okay, what did you do?
It's not really a system I'm familiar with,
Mhm.
so I attempted to look through, the online court system to see if any of that documentation, or through the family court system,
Mhm.
to see if that order had been, posted within it, and I did not see it in it.
And when did you do that?
I don't recall which date I did that.
Would you agree that it was somewhere between the 7th and the 10th?
Yes.
So you were, between the 7th and the 10th, you looked and you weren't able to see that that order was entered either?
Correct.
Nothing further, Judge. Thank you.
Any redirect?
I just want to reiterate,
Did she express some doubt over the veracity of it on 7th of February of the order that you presented to her?
Yes, she didn't think it was a real document.
Okay. And then she might have also expressed some doubt on it on the 10th.
Yes.
That caused you to follow up with the court on the 13th.
Here's something to think about. Trooper Pizzell only contacted the court because Miss Lovely asked him to. She challenged the legitimacy of the document, and he gave her the benefit of the doubt. He didn't force compliance. He verified it for her, and still, she ignored it. This proves she was given every possible opportunity to avoid charges. The system bent over backward to help her, through courts, law enforcement, and direct engagement. And that's why this case is moving forward. Because once you ask for confirmation, receive it, and still disobey the court, there's nothing left to argue. If anything, this sequence shows the court and the officers were patient. Miss Lovely was given days to comply, and instead, she doubled down. And that makes what happens next inevitable.
Yes.
Okay. Thank you. I don't have anything.
All right, thanks, Trooper.
Thank you.
You're all set. Any additional witnesses?
I don't have any other witnesses, Your Honor.
Any witnesses for the defense?
No, thank you, Your Honor.
All right,
Your Honor, at this point in time, I motion to find the defendant over on the charges contained within the information, the one count.
respond.
Your Honor, I would object. First of all, it seems to me that based on the testimony, this entirely occurred in South Lyon. So I'm not really sure that there's jurisdiction. This appears to have, the child was in Oakland County the entire time. So I think there may be a question as far as venue. However, on the facts of the case, the testimony is relatively clear from the trooper that he showed her this order on the 7th. She indicated to him that she didn't think it was accurate. They both, I think, he independently attempted to look in Odyssey, couldn't find the order. There was an order, a motion that was made and denied, which was testified to by Mr. Johnston. So at the very least, it makes it clear, I think, that there's confusion over what order would be entered or what order would be accurate if there was, this motion was already denied on one motion and then entered on another. Additionally, Your Honor, when the officer presents this to her and she indicates that she doesn't believe it's accurate, he agrees to look into it. Just a reasonable person would interpret that the officer is considering that possibility and is looking into it. If the officer is looking in to determine whether or not the document is accurate or true, it's reasonable for a person not to follow it until they're told that it is.
Or that they go and determine that themselves.
And she hasn't testified that she attempted to do that yet. However, need to prove that she attempted to do that, and it wouldn't have done any good because the officer already indicated that order was not in the system yet.
Or that he couldn't find.
Or that he couldn't find it. But it does take time for those orders to appear. She couldn't independently verify it. By the 10th, that's now her parenting time. She hasn't received verification from the officer yet, who's indicated he's going to look into it. He does. She gets verification on the 13th, but that order does not change, and the court indicated that order does not change her parenting time. Now she's into her week. So the child stays with her until the 17th, and then the child would go back to the child's father on the 17th, according to the parenting time agreement. That's obviously changed by the February 14th order, but that's not really what we appear to be discussing here. The issue seems to be this time period from the 7th to the 10th. Because the order that issued on the 14th said she had until the 24th to return the child.
This is where the prosecution hammers its closing argument, and they do it with precision. They anchor everything to February 7th, the moment Miss Lovely was presented with a valid signed order and chose not to comply. That date becomes the legal starting gun for willful interference. Notice how the prosecutor cuts through the emotional fog. No distractions, no detours, just facts. She was told, she refused, she didn't return the child for days, period. They even give her grace, acknowledging she had 24 hours to comply. But instead of using that time to seek clarity or follow the law, she doubled down. And here's the clincher. The prosecution doesn't just argue legality, they argue pattern and intent. They show that each missed handoff wasn't accidental, it was a decision, repeatedly. For the court, that's not a civil issue, that's defiance, and it's the backbone of this case.
The child was taken by the father on the 16th, so we never got to the violation of that particular order. So based on all of that, Judge, based on what the officer told her and what the officer did and how it would imply to her the possibility that this order is potentially untrue or invalid, he couldn't independently verify. Couldn't tell her that it was accurate until her parenting time had started. I would ask the court to dismiss the charges in their entirety. If nothing else, perhaps it's the basis of a show cause that could have been handled in family court, but as far as a parental kidnapping, I don't think it rises to the level to criminal conduct when the officer himself agrees to take on the task of verifying the veracity of the document.
I would ask the court, I know the court's probably already aware of this. Anything that our arguments are not evidence, but anything that Mr. Overwater argued was that what she did, there was no testimony to that. So let's just focus on the evidence that we have. Take or retain for more than 24 hours the child with the intent to detain and conceal the child from the child's other parent. What do we have? On the 6th, CPS says that Mr. Johnson testified, CPS indicates that child custody is to resume as normal. At the 7th, he's supposed to pick the kid up from school. The child does not go to school that day. That prompts Mr. Johnson to then turn his investigation both to the police as well as friend of the court. He hit this order. He talks with the trooper. Trooper turns around, talks to mom. At that point in time, mom is on notice. She says, I'm not returning the child. I don't believe that's real. Fast forward to the 10th. He tells her, you have 24 hours to do this, or you could be looking at charges. She rolls those dice. She says, well, I'm throwing it. The 10th, nothing changes. Custody has not changed. Mr. Johnson testifies he has not received his kid, his child, in those intervening days. Trooper Pitzel goes back on the 10th, says, hey, what's the deal with this order? She says, I don't believe it's real. I'm not giving the kid back. He verifies it on the 13th at her request, verifies that it was in fact real. She says, I'm still not going to return the child. It is what it is. 24 hours she had to return the child or comply with the custody agreement. That order was entered on the 7th. She was made aware of it on the 7th. There's no testimony to suggest that there was anything else that was going on other than there was this order that she had to comply with, and she didn't comply with it between the 7th and the 10th. So for that, Your Honor, as the court knows, this is an order out of our circuit court that gives us court venue and jurisdiction. That's where the order arises out of. That's where the underlying custody agreement comes out of, this court, giving this court jurisdiction over this matter. Therefore, I would ask the court to bind the defendant over on the charges contained in the information.
I think there may be two bases for certain venue, and jurisdiction of this court, the one that's brought up by the prosecutor, so I can dispose of that. It's enforcing a Washtenaw County order. Also that the venue is stated on the complaint is Northfield Township. There's going to be the 1 mile, certainly, for any conduct that occurs within that. So the court does believe it has jurisdiction and the venue is proper here. As with respect to the elements of this offense and when it occurred, what a wonderful world we would have if defendants who were presented in order by a peace officer were able to say, I don't believe the order, and just not comply.
Judge Simpson delivers a masterclass in courtroom authority here, and a warning for anyone who thinks they can outmaneuver the system. He drives one brutal point home. I don't believe this order is not a legal defense. You don't get to opt out of law just because it doesn't suit your feelings. If you're unsure, you verify. You don't delay, disobey, or disappear. And Miss Lovely did all three. This moment matters because it clarifies the court's expectation for every litigant. Compliance isn't optional. You don't wait for someone to drag you into the courthouse. You follow the order and raise objections through proper channels. The judge isn't just frustrated, he's insulted. And he makes it clear if this kind of blatant refusal becomes common, the entire justice system loses credibility. It's not just about Miss Lovely anymore. It's about setting a precedent. If you get a court order, follow it.
Without doing their own check, without doing their own, I guess, footwork on it. Certainly, officers may assist in that, but once presented with the order, it is the person who is subject to that order's obligation to follow it, check it, verify it, and make sure they're in compliance with it. This defendant didn't do that. She just said, I don't believe this order, and then left it to everybody else. What is also clear from the testimony is that the parental father knows that it's his time and he has that order. He follows all lawful means to obtain the order. The order gets served on the defendant. The defendant says she doesn't believe it. The trooper told her she had 24 hours to comply with the order. She didn't. The question then becomes, well, and that's going to be from the period really from the 8th, because of the 24-hour period, to the 10th, that she did not comply with the order. And that in and of itself constitutes that offense. I think it may be a question of fact for the jury as to what the February 17th order means in terms of it going back, because there are different interpretations. One interpretation of that order, on the face of that order, one interpretation is, if you've interfered with my custody, then I basically take your week. So I still do the off and on, but now the weeks are reversed. That's one way to interpret that order, because it's just week on, week off. The other way to interpret that order is we go back to the normal schedule. I don't know which way that order really reads on the face of it, but in either event, I mean, and that to me says that that's going to be a question of fact, because it may very well be that the defendant then interfered with what would become the child's father's week.
Judge Simpson cracks open a rarely discussed twist in custody law: retroactive interference. Here's what he's saying. Even if the schedule was confusing, even if the weeks were off track, Ms. Lovely's failure to comply reshuffled the calendar, and that reshuffle robbed Mr. Johnston of his parenting time. This is next level legal reasoning. because it doesn't just ask whether Miss Lovely violated the original order. It examines how her refusal rippled through future weeks. It's the kind of interpretation that makes family law so complex and so emotional. When one parent breaks the rules, they don't just hurt the other parent, they rewrite the entire co-parenting rhythm. This ruling sends a clear message. Custody isn't just about one day or one weekend. It's about the integrity of the entire agreement. And when that integrity is broken, so is the court's patience.
That would have previously been her week. Because that week on didn't happen. So that's a reasonable interpretation in this court's mind, certainly, and having seen it before, of these orders. Under either analysis, and again, I'm here to decide whether or not there's probable cause to believe that a crime was committed, not as to whether or not she has complied with the order, nor to necessarily give an interpretation of that order. That's for other proceedings. Given all of that, the court does believe that the defendant has committed the offense of kidnapping, custodial interference, and that people have sustained their burden of showing that by probable cause, either, so that we're clear, either as to that period after being presented with the order and not complying within 24 hours, or in retaining the child if there were a switch of weeks for that following week. Under either one of those analyses, the people have sustained their burden. And therefore, the defendant is bound over to stand trial on this charge.
I'll acknowledge receipt of the information, Your Honor. I'll waive its formal reading, and my client will stand mute as to the allegation.
Defendant, every way, formal reading, standing mute. Court will enter a not guilty plea. All right.
As a point of clarification, if I may.
Yes.
The court's recitation on the find over, the court referenced an order of February 17th.
Oh, I meant February 7th.
Okay. Perfect.
If I said 17th, I meant February 7th. All right. Court will indicate the defendant standing mute. Enter a not guilty plea. Pretrial will be set for
October 16th at 1:30 p.m. with Judge Slay.
October 16th, 2023, 1:30 before Slay. Is that
That's a Monday.
That's a Slay Monday.
Your Honor, there is the violation matter. I don't know
Yes.
if the court wanted to address that.
I do. So that we understand, and I don't how we got here, that the court had ordered Miss Lovely on July 27th that there was to be no posting, commenting on social media regarding this circumstance, or particularly the child, or anything having to do with this. All social media that she had previously posted regarding this case was to be removed, and that the court was very specific that it included anything to do with the child directly or indirectly. That was on July 27th. We returned for a hearing August 17th. The people, I think, filed a motion or a request to an emergency motion on the 9th, I think it was, to revoke her bond. At that time, the court reviewed it. There was a partial hearing on that. Well, there wasn't really a hearing on that date when she came back on the 17th. Based upon what the court saw in the court's previous order, the court did indeed revoke the defendant's bond, remanded her to the Washington County Jail. Have subsequently released her from the Washington County Jail, but had set a bond hearing to address the issues in this case, because there was a claim that the subsequent posts were not with reference to the case. And that's where we are.
And I believe that subsequent post was something about a stalker, and then she referenced that, or at least the indication was that was in reference to a landlord or some kind of landlord-tenant dispute.
Correct.
That is my understanding as well.
Where was that landlord-tenant dispute heard? And what was the name of the landlord?
Her name is Emily Knox. The landlord-tenant dispute was at Water Edge Apartments.
Where was the case heard?
There was no landlord-tenant case. We just had a eviction case coming from the property management. But there has been police report filed for different disputes. So previous property manager was not.
So there was no landlord-tenant action that was filed?
Not through the courts. There was a police report. Police has been called. That's made and only from the associated with the case. That we had to become our eviction through Water's Edge because of the situation with the old property manager. All right, and that's been taken care of.
It's my understanding that there was an actual court case, but within
That's what I had.
50 seconds.
Excuse me. The eviction case.
Right. That's Water's Edge Apartments versus Justin Hatchett and all occupants. So
Who is Justin Hatchett?
I believe that's her
That's
significant other, fiance.
we're both on the lease. He just was named first.
So how does this relate to that?
There was an incident.
I'm sorry, Judge. How does what relate to that?
How does the stalker relate to that case? Because I'm a bit confused only because before she had told me there was a landlord-tenant case. Then she told me today there isn't a court case, but now I find out that there is a court case, and I'm now trying to relate the language that she was using to that case.
But my client indicates, judges, that she was being harassed and stalked by the former property manager. What was the name?
Amberly Knox.
Amberly Knott. And that's the person to whom she was referring when she made that post. There is an email addressed to Ms. or to purporting to be to Amberly. I don't know if that's been tendered, but.
I find it interesting. There was also this issue with the GoFundMe, right? And so the GoFundMe is the GoFundMe. I recognize it's been disabled. It has not been deleted. But in that language, when she's talking about what had happened, she says, still being harassed, stalked, manipulated, and talked about by my ex-husband. So she's referencing that same language that comes in, what was it, in that post from, I think, July 27th, which that apparently happens to coincide with one of our dates here.
Yes.
So it's just too convenient. And I find it too remote to refer to a stalker or a landlord as a stalking, because a landlord is a stationary kind of thing. It's the building. So it's just strange, and it seems too remote.
So Judge, the GoFundMe was early July. That was before, I believe, the court's order, is my understanding, when that was created, and it has been disabled. A person can have more than one person harassing them in their lives. So while she may have had, obviously there's a difficult relationship that she has with her ex-husband, that does not mean that she's not also having issues with this landlord property manager. Again, this isn't the owner, this is the person managing the properties who's there in the areas, driving around in a golf cart, is watching her and has been harassing her. That is what she's reporting. I would ask the court, based on the vagueness of what that post was, to dismiss the bond violation. She's already spent, I believe, a week in jail as a result. And I've admonished her to stay off of social media in its entirety during the pendency of this case. And I don't believe there's any indication that there have been any issues since she was released from custody.
Well, let me just say this. I don't think the defendant believes any court's order. It distressed me, first of all, in coming back, that there was a violation of my order. Right? Then when I'm listening to testimony here, Judge O'Brien issues an order. She didn't want to follow it. She just doesn't believe that people are going to issue orders that may affect her and that she can just decide to do things as she will. I hope her time in jail has sort of bemused her of that idea, especially when it comes to me. I think she's also going to run into a different type of animal well, I don't mean that in a bad way, but a different type of judge when it comes to Judge Slay. And I would almost just dare her to not follow Judge Slay's order to the letter. Because 7 days probably won't be long enough. What I'm going to do is I'm going to find that there's a violation, sentence the defendant to 7 days credit for the 7 she served. I'm also going to issue a new order, or as part of her order going up. And I think it's wise advice, Mr. Overwater. The defendant is not to be on any social media. No use of social media. Ma'am, do you understand me? Thank you.
Thank you.
Otherwise, her bond will continue at this point.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
And there it is. The gavel drops on a courtroom saga filled with missed pickups, ignored court orders, police visits, and legal defiance. Judge Simpson has made it official. Miss Lovely will face trial for custodial interference. Let's break down what this really means. Over the course of this hearing, we saw a clear legal pattern emerge. A father following lawful procedures despite personal frustration, a court issuing not one, but 2 enforceable custody orders. A law enforcement officer who verified everything, even when he didn't have to, and a defendant who had multiple chances to comply, but chose not to. What started as a custody disagreement turned into a criminal charge because of repeated refusals, crossed state lines, and an unwavering belief that personal judgment overrules the law. In the end, the court didn't just focus on intent, it focused on actions, and those actions, silent refusals, broken itineraries, and ignored orders, spoke louder than any defense. Judge Simpson's final bond condition says it all. No more social media, no more excuses, follow the rules, or jail time won't just be temporary, it could become the main event. This case is a wake-up call for any parent involved in co-parenting conflicts. The courtroom isn't interested in your social media posts or your private theories about what's fair. It cares about compliance. And when you ignore the system pushes back hard. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You don't want to miss what's coming next.